All right, it's 2:05. We will reconvene this matter. Before we move to closings, at the beginning of the day, I had directed, or we had directed, Mr. Sullivan to develop a list of any BMPs that the town was interested in that were otherwise not on the 2A, because we felt there was some overlap. I've been informed that in my inbox is a document. I'm not sure what it is, but I would call upon Mr. Sullivan to address this issue at this time before we get into closing, so we could kind of be done with the substance.
Yes, Chairman Robbins. Basically, what the document is that I sent you is, and I sent copied opposing counsel. It's a spreadsheet. It's an Excel spreadsheet that shows certain BMPs that are basically, it references the BMP in the operator agreement, gives a description, basically what the BMP says. And then it asks, and then there are two more columns that say, is it included elsewhere or covered elsewhere? And for the BMPs that are in the green font, they are covered elsewhere, either by COGCC rule or by CDPHE recommended BMPs, which were presented to the commission yesterday. For the BMPs that are in red font, there is no corresponding BMP in either the CDPHE recommended BMPs or the COGCC rules.
Okay, so the answer is that you would be advocating on behalf of Erie for the commission to incorporate the red language. Is that accurate?
Yes, because those ones are not covered anywhere else. And again, the BMPs in the operator agreement were intended to supplement state law. And obviously, if state law is providing for a more stringent requirement than the operator agreement BMP, there's really no need to do anything. I mean, the state would have the discretion about how that gets enforced.
All right. I'm going to do something that's also a little bit out of order, but Ms. Larson, do we have anybody from staff that might want to speak to this issue?
I can. I'll
Director Murphy showed up. Director Murphy, I hate to put you on the spot, but I think you've been monitoring this discussion, and at least two commissioners have expressed some concerns about incorporating Erie's BMPs into the Form 2A. I expressed the reasons for my concern, and I think Commissioner Messner echoed in on that. Does staff have any perspective on all this?
Thank you for the opportunity, Chair, and thank you, commissioners and participants. The staff's longstanding position, i.e., which predates 181, is a preference for avoiding including BMPs that are negotiated outside of our process and generally maybe outside of our expertise, for many of the reasons that I think have been discussed today by you, Chair, and you, Commissioner Messner. Again, to me, this is a position that staff has taken, and I think the commission has historically supported, that predates 181, and to me 181 only reemphasizes the importance of entities taking on the responsibility for enforcing their own provisions. It makes me uncomfortable to put my staff in a position to be looking at a permit and trying to decide which is more protective, ergo which needs to be enforced. I think that comes down to a legal call, and I'd sure hate to find out 3 years down the road from a district court that we made the wrong call. We take enforcement of our rules seriously, and I think that we are in the best place when we are enforcing the rules that have been adopted by this commission and are implemented by our field teams, our enforcement, our field teams, whether they're compliance, environmental reclamation, et cetera. It also keeps us out of, some of the concerns that may arise from, this could also apply to it. Sorry, taking one step back. We also don't incorporate terms that are part of a surface use agreement, for example, between the private surface owner and the oil and gas operator. Those folks can negotiate terms that are appropriate for them, but don't have much bearing on what our authority or expertise is. So to really kind of summarize, I appreciate, and I think we've been working very closely and alongside Erie for a long time on these issues. And I know it's been important to Erie historically to make this ask and have terms or have BMPs put into the commission permit related to their operator agreement. And I respect the integrity and the ability for Erie to enforce those terms separate and apart from our process. So that's a long-winded way of saying it's my strong preference that this commission does not incorporate BMPs from Erie's operator agreement. I think Erie has full authority to enforce those terms. And I don't want to, again, I worry about my staff interpreting terms of somebody else's agreement.
Great, thank you for that perspective. That's helpful. Okay, well, Mr. Sullivan, we now have your document. I just opened it up so I can see what's read and what's not read. I think we've addressed this matter. And so at this point, I think we would move to closing arguments. And let me ask a question of the parties. It looks like the order of closing was Crestone and then Broomfield and then Erie, if any. Is that what y'all agreed to? Normally, I would have assumed that Crestone would go last as they carry the burden of proof, but I'm fine going with this order. Ms. Jost?
Yes, thank you, Chair. My understanding was Crestone would go last. It would.
Ms. Jost, you appear to be frozen.
Mr. Chair, can you hear me okay?
Yeah, I think so.
Okay, yes, thank you. And it was my understanding that Crestone would go last on the closings.
That seems fair to me. Are you comfortable with that, Ms. Paranos?
Yes, that is correct. We agreed to that.
Okay. Then why don't we do this? Let's just reverse it completely. Mr. Sullivan, I'd like you to go first if you have any closing argument.
Mr. Chair?
Yeah.
If I may.
Yeah.
Ms. Jost and I apologize, Mr. Sullivan, we did not include you in this conversation as it didn't seem relevant to your client's interests. Ms. Jost and I have been discussing some additional best management practices that the city and county of Broomfield has proposed to Crestone that the COGCC apply as conditions of approval in the event that you choose to approve of the pad. We thought it might be helpful if I just were to relay those now before we get into closing arguments. However, if you would prefer, I'm happy to.
No, that's fine. And pretended like I asked you this question so it doesn't count against your time.
Thank you. I appreciate that. We have a few additional measures. So we have endeavored hard to look back at our data and identify best management practices that would address some of the uncontrolled sources of hydrocarbons that we identified at the extraction well sites. And in addition, we've identified some additional air monitoring that we think would help provide just some safeguards to some of the residents that live within the neighborhood that's between the COGCC pad and the United and Interchange pad. And so those are as follows. We suggest the following, and these specifically, we would suggest the commission add these to the pad if it approves COGCC East as conditions of approval. Excuse me. So to reduce emissions, the first would be to ultrasound the separators and inlet piping prior to flowback operations to ensure an appropriate thickness to prevent leaks. The second would be during red flag days with high winds to not conduct any hot work. This would reduce the risk of a grass fire. The third is to use an emission filter apparatus to reduce emissions produced by vacuum trucks while emptying separators during maintenance and emptying sand holding tanks during flowback operations. These were two sources of emissions that we identified as the cause of uncontrolled emissions during pre-production activities. The fourth is to install wash lines in the mud gas separator and use an eco tank to prevent clogging during drilling. This will reduce the risk of a fire, which is something that did happen at one of the extraction well sites. And the fifth is to use electric engines to power coil tubing. This is also to address emissions that we identified during coil tubing. And the last is to plug and abandon the 19 lower producing and inactive wells in Broomfield that we had identified as problematic in our current conversations with Crestone. And then we have 3 air monitoring BMPs. So to monitor for pollutants, we would request that Crestone install and operate community monitors for hazardous air pollutants in particular in the residential neighborhood in Broomfield that's located within 2 miles of the COGCC East pad and the United and Interchange pad, that's Interchange A, and also to consult with Broomfield on the design of the monitoring system and provide Broomfield with monthly monitoring reports. 2 more. One is to provide Broomfield, these both relate to the Reg 7 requirements, so that Crestone needs to comply with. So the first is to provide Broomfield with the monthly reports that it provides to the Air Pollution Control Division in accordance with Reg 7, Part D, Section 6, C2B. These reports provide information on the AQCC required air monitoring during pre-production and the first 6 months of production, and similarly provide Broomfield with the same notices that Crestone provides the relevant local government with respect to that CDPHE required air monitoring, which would include a notice of responsive actions taken in response to elevated air monitoring values. Thank you.
Ms. Haranos, the red flag days, I was trying to take notes for high winds to do what?
To prevent, so it would be to not conduct any, I believe it's hot work. So that would be, I think, work that could incite a flame during those red flag days to reduce the risk of a grass fire.
Okay. And then Ms. Jost, if you could appear. Your client is agreeable to these additional conditions of approval if we get to that point?
No, Chair. We need to make a few statements on the record because while it was discussed, and I did tell Ms. Pranos too that Crestone, it's not agreeable to any of those. Broomfield has had since 2020 to bring BMPs to Crestone. When Crestone started its WOGLA process that it did not participate in, Broomfield could have brought this to Crestone to discuss at any point in time during the discussions on the COGCC East pad and could have proposed these potential BMPs. In fact, in this proceeding alone, there were at least 5 chances for Broomfield to bring in these BMP asks, one of which was the petition, the pre-hearing statement, the responsive pre-hearing statement, the PowerPoint presentation that was submitted prior to hearing, and then at the hearing itself yesterday, Ms. Pranos and I did have an opportunity chance to talk at 9 o'clock last night about these, but Crestone can't really analyze these in real time and on the fly here. These are substantial VMPs, and as you know, this location is already highly regulated. It's going to have almost 100 BMPs placed on it, and frankly, it's those BMPs are appropriate, even as noted by Ms. Oates earlier today. From the standpoint of additional information on these BMPs, I would like to bring up Kathy Stearman, if I may, because she would like to address some of these BMP requests as well for purposes of Broomfield's ask. So Ms. Stearman, if I may have you present.
Thank you, Ms. Jost. And yes, I would like to give a quick thanks to our ops team who answered my phone calls this morning at 6, trying to walk through some of these because I'm a little unfamiliar with some of the asks here. So obviously we have to make sure that BMPs are safe before we agree to anything. So I did get a hold of some of my team Maybe we should talk a little bit about some of the monitoring. We do know that Erie's program has air monitors that are going to be south of Cosla East. And like we said earlier, we are open to and would certainly want to keep the lines of communication open with the local governments. And as we all know too, we will be filing for an air monitoring plan, which will have Broomfield and other local governments who are able to weigh in on that at the time. And I think those are good collaborative efforts to come together and come up with a good monitoring plan that's protective of public health. Again, the reporting of exceedances and alerts are all negotiated in our air monitoring plan, and that kind of creates a good path of compliance. My air team also does a lot of air compliance, which is really critical to us to make sure that we're keeping all of our compliance requirements straight. So keeping that through the air monitoring plan makes sense, and it also gives a lot of people opportunities to weigh in. In relation to the ultrasounds of separators, I wonder if we're asking to add a BMP for a process that won't even be on the pad. We've talked about how we're going to flow back to pipeline. We will not have a flowback kit on site, so adding ultrasounds to separators for a flowback process may not make sense. I think we also enhance our piping to a different grade. So from what I understand, the ultrasound didn't make a lot of sense from our ops field team. I also understand that hot work isn't conducted during high wind days or red flag days just because you can't do it, just by the nature of the fact that it's windy. And then also getting to the vacuum trucks and the emissions filter, we do our well maintenance to our pressure vessel. So adding a filter system to a process that may be not even coupled up to that, I don't know if it makes sense for this pad. So again, it's just kind of the process of further understanding what these asks are and how they would even relate to COSLET. I am not going to be able to speak to what a wash line on the mud gas separator is specifically. I do know that the drilling operation needs to maintain a very safe process, so I wouldn't want to talk about that until I had some input from our drilling experts. Finally, the electric gas engines to power coil tubing. I think Ms. Pranos referred to some of the emissions seen during that process. They were probably methane at the time or a venting event. So electrifying doesn't translate to what the air monitors were seeing at the time, having been involved with some of that real-time interaction with some of the Broomfield folks. So I hope that kind of helps put it into context on how we're trying to understand these on the fly.
Thank you, Ms. Stearman. Mr. Chair, I do have one more, I guess, add to the request for the 19 wells. Crestone does have a list of wells that will be P&A'd that are based on engineering and risk priority, including wells within disproportionately impacted communities. Broomfield's wells don't hit that level of risk at this point in time enough to blindly apply that into the P&A program as of today. So thank you for the opportunity to respond.
Okay. So none of that counted to either one of your times. So you still have whatever you had reserved for your closing. Anything, I don't believe I need to hear anything more at this time on those issues. If that's the case, then we're going to go back to the regularly scheduled programming, which is hearing from Erie if Erie desires to do any closing.
Thank you, Chairman Robbins, and thank you to all the commissioners for their patience and attention over the last couple of days in this OGDP hearing matter. Erie wants to reiterate that the commission adopt the stipulation that was agreed to by Erie and Crestone, that the operating agreement BMPs be included as part of the approval in this matter. Those BMPs were developed jointly by Crestone and Erie and intended to supplement and be in addition to state rules and regulations. And the the BMPs in the operator agreement are intended to protect public safety, health, and welfare, and the environment, and are consistent more or less in that respect with the COGCC's own regulations since Senate Bill 181. I would direct the commission's attention to pages 50 through 59 of Crestone's presentation yesterday, where they compared all of the BMPs, and there really isn't any inconsistency, despite I do respect what Director Murphy said, but it only, in the larger picture, if making an Erie BMP part of the approval protects public health, safety, welfare, and the environment just a little bit more, that's not a bad thing. And in the event that there is a conflict, BMP 31 in the operator agreement says that the CDPHE's authority, if it's the more stringent requirement, and its enforcement decision is what's going to govern over the corresponding BMP in the operator agreement. So I would like the commission to seriously consider including this in its order of approval, if that's what the commission decides to do. Thank you.
Thank you, Mr. Sullivan. I believe we now will hear a closing argument from the city and county of Broomfield.
Thank you very much, Mr. Chair. And thank you to all of the members of the commission, Director Murphy, staff, and council and parties. We greatly appreciate your thoughtful questions and attention to this matter over the past 2 days. You have heard a considerable amount of highly complex technical information. In my closing, I am going to attempt to distill that down into key points as we see them. First, Broomfield stands behind the methodology and results of its health study. This study was done using valid scientific methods that have been utilized by other peer-reviewed studies. The study's findings are similar to the findings of other peer-reviewed studies that relied on survey results. Our study found a statistically significant association between proximity to multiple unconventional oil and gas sites and the reporting of adverse health impacts. This finding is consistent with findings from other scientific studies that demonstrate an increased risk to public health for persons residing near oil and gas facilities. Our health study is the first we are aware of that looked at the impact of emissions from multiple unconventional well sites rather than just one facility on health. Second, Broomfield's air monitoring network has identified elevated levels of hazardous air pollutants both near the extraction well sites and in neighborhoods. Specifically, we identified 12 one-minute benzene samples during the fourth quarter of 2021 that we have extrapolated to exceed the short-term health-based guideline for benzene of 9 parts per billion. That's using the method that Mr. Brent described. In addition, 4 of our neighborhood canister samples identified elevated VOCs with measurements that are 50 times to 200 times normal background concentrations. 2 of these have clear oil and gas signatures, and 2 show a mixture of oil and gas and combustion sources. Broomfield inspectors have correlated some of the elevated levels of benzene and other VOCs to pre-production activities occurring at the well sites where uncontrolled hydrocarbons were exposed to the atmosphere. Specifically, these activities include when hydrocarbon-rich drill cuttings are sent through mud shakers, which separate solids and liquids during mill out after hydraulic stimulation, and during the discharge of collected sand into storage containers during flowback prior to closed loop production. While the number of detected levels above background that show a clear oil and gas signature may seem small, it is critical to underscore the limitations of our monitoring network. It is simply not feasible nor remotely economical to install and operate monitors at every home within 2 miles of the 6 pads in Broomfield. And even if we had more monitors, wind direction and speed can dilute and change the direction of air pollutants, such that a plume captured at a sensor near a well site may not be captured at a sensor in the neighborhood. That is why we must use modeling to extrapolate measured concentrations to 1-hour averages that we can use as a benchmark to compare pollutant detections to health-based guidelines. We are asking you today to apply the precautionary principle. Here, that means we are asking you to be conservative in your permitting decision and to not allow the construction and operation of yet another multi-well pad within 2 miles of residents who already live within 2 miles of 2 other multi-well pads. That's a lot of 2s. Broomfield identified a residential neighborhood in Broomfield that is shown on our Exhibit B that is within 2 miles of the Coslet East pad and within 2 miles of the United and Interchange A pad in Broomfield. We are asking you to consider the results of our health study and our air monitoring data, both of which are specific to Broomfield residents, and to acknowledge that our data raises serious concerns regarding cumulative impacts. We ask you to consider the limitations of current health guidelines, which do not cover exposure to multiple pollutants, but rather are only available for a select number of compounds. The current health guideline for benzene was developed over 30 years ago, and we maintain that it is outdated. We believe our evidence weighs in favor of a denial. If, however, you choose to approve of the Coslet East facility, we ask you to take additional steps to protect public health. We have suggested Crestone take additional measures to both reduce and monitor for emissions, including the uncontrolled emissions Broomfield identified at the extraction well sites. We respectfully request the Commission require these additional BMPs as conditions of approval in the event you approve of the proposal. We appreciate Crestone's willingness to rapidly review our list and would welcome the opportunity to discuss the feasibility of our proposed BMPs with Crestone in more detail if the Commission would allow. Thank you. That concludes my closing statement.
Thank you. We now will have a closing statement from Crestone.
Great. Thank you, Chair. Thank you, commissioners, council, staff, and parties, and everyone that has stuck around and listened to this hearing for 2 days. As you deliberate, Crestone respectfully requests that you consider several significant points that support an approval of the OGDP application. First, Crestone has presented substantial evidence through witness testimony, exhibits, and discussion that the Coslet East oil and gas location is the most protective location that meets the intent and purpose of Senate Bill 19-181 and the mission change rules. Crestone has applied almost 100 best management practices from CDPHE, Weld County, Erie, and the surface owner to its operations, including stringent emission practices and technologies on this location that serve to minimize the potential adverse public impacts. They've applied a condition of approval, limiting development on the location to 3 years. They've implemented or will implement continuous optical gas monitoring. There is 0 permanent produced water or oil tanks. It is a 3-phase oil, gas, and water takeaway and use of electric drilling rig, among other things. The CDPHE confirmed this morning that Crestone's BMPs minimize risk and are appropriate for this location. Crestone designed this location to avoid first, and then minimize and mitigate the extent and severity of the impacts that cannot be avoided by applying the BMPs, operational techniques, and the condition of approval just described. Crestone also delineated the statutory jurisdictional authority, question brought up by Chair Robbins, from the contractual requirements asserted by Erie. Although this is a unique location where 2 counties and 1 municipality converge, Crestone confirmed that Weld County is the relevant local government under 2920-104, and that the Commission is the governing state agency under 3460-104 and 3460-106, both of which require permits and both of which can enforce their own permits by statute. Crestone also confirmed that Erie's approximate local government that has a private contractual agreement with Crestone under which Erie can institute contractual remedies if it deems there to be an issue. To be clear, Crestone is not seeking to modify any statutory authority of Weld County or the commission by referencing the Erie operating agreement. Second, Crestone provided detailed information to the 2 residential building unit owners within 2,000 feet of the Coslet East location, engaged in discussion with those 2 owners, and ultimately obtained 100% informed consent from those persons, placing this application under 604B1. Crestone also has an approved WOGLA permit from Weld County through a lengthy public process that neither Erie or Broomfield participated in. We have a surface use agreement with the surface owner who does not object to the location. And after a detailed and thorough analysis of all the documentation submitted through the OGLA staff and the hearing staff, as well as Erie, Broomfield's, and the other party submissions, a director recommendation for approval. Third, Crestone fully understands the comments from Commissioner McGowan and Commissioner Messner about Crestone trying to P&A more than 6 wells as part of this development. Civitas is aware of the immense community benefits that can be achieved through the plugging of eligible legacy vertical wells, and it maintains an active plugging and abandonment program. Civitas has plugged and abandoned more than 110 eligible legacy vertical wells in 2022 so far, and plans to plug approximately 150 by year end. And further, Civitas has entered into a voluntary agreement with this commission to plug and abandon more than 40 sensitive or higher risk orphan wells not operated by Civitas that would otherwise be the responsibility of the state's orphan well program. But Civitas also has resource limitations that require the company to prioritize its vertical well portfolio based on the most eligible candidates for plugging and abandonment. The company evaluates each well in its portfolio on a number of factors, including mechanical integrity, emissions, proximity to local communities, production profile, and other factors in order to identify those high priority legacy vertical wells that should be plugged and abandoned near term. The 19 wells identified by Broomfield were not currently competitive with other higher risk or higher sensitivity wells in Civitas portfolio, and Civitas believes it to be in the public interest to focus its resources on higher priority P&A candidates in the near future while continuing to evaluate its P&A portfolio on a continuing basis. Fourth, Broomfield is effectively asking this commission to relitigate, or even more pointed, to disregard the mission change rulemaking that this commission and hundreds of stakeholders recently engaged in. Broomfield attempts to change the rules by making it a 1 to 2 mile mandate for OGDP applications and Form 2As as it relates to cumulative impacts. What Broomfield is seeking as a basis to deny the Coslet application is not in the rules. It was not intended by the mission change rulemaking, and this commission should not be influenced by Broomfield to disregard its recently adopted rules that govern this application. Broomfield's argument is well outside the scope of this OGDP application and should not be relied upon by the commission. And then finally, scientifically, and as shown by Crestone's expert public health witnesses, the health survey is not an appropriate basis upon which this commission should rely to determine if oil and gas development causing impacts to citizens or resulting in perception-based symptoms that were primed to relate to oil and gas operations. Broomfield itself stated, and I quote, "The study cannot determine if the self-reported symptoms were caused by exposures to emission from oil and gas well sites." And Ms. Weisner expressly confirmed that bias exists from those responding to the study, quote, "who are against oil and gas," end quote. As Dr. Hall stated, a cross-sectional survey cannot determine causality because exposures are not established before disease. Although the process used to gather information may not be an issue, the unintended consequences of the response information to Broomfield's health survey is that the responding citizens were primed to think about oil and gas and their health as they were completing the survey, which leads to obsequiousness bias. This is especially true where Broomfield presented the survey by expressly stating, and I quote, "These questions will ask for health and demographic information to better understand resident health near and away from oil and gas activity," and that, quote, "your responses will have the potential to help guide further policy conversations around oil and gas in our community," end quote. These guiding factors resulted in study participants to have a form of bias in responding to the survey instead of looking at other possible reasons for their symptoms. colds, flu, COVID-19, pre-existing chronic conditions, or behavioral and lifestyle factors. In addition to Crestone's stated concerns with the analysis of the health survey results, Crestone presented compelling evidence that Broomfield's expert witness analysis and testimony presented was taken out of context, or at a minimum, presented without science-specific important facts that serve to confirm that all air emissions monitoring readings of chemical concentrations, specifically benzene, at the community air monitoring locations in Broomfield were actually below the health guideline value, which indicates that the major concentrations are unlikely to pose adverse health impacts. Broomfield is arguing that no oil and gas activity should occur because of the HAPs. However, Broomfield fails to acknowledge that even if oil and gas activity were not present, HAPs still exist in communities, as addressed by Dr. McMullen, who confirmed that the best management practices utilized at the Coslet site will reduce and minimize adverse impacts, if any exist at all. And then finally, using publicly available real air data from CDPHE, the town of Erie, Broomfield, and CTEH, Crestone's experts showed that multiple studies of pre-production and production operations and the air measurements associated with each phase resulted in a similar result, that no public health impacts were found from Crestone's and Extraction's well pads. Crestone asks that this commission give serious weight to the results of the CDPHE, Erie, Broomfield, and CTH studies, because this area of Colorado is likely the most monitored in the state, maybe even the nation, for air emission and potential health impacts. So to conclude, Crestone would respectfully request that this commission approve the 1,920 acre Coslet East OGDP application and allow 19 new wells to be developed from an expanded multi-well pad, along with the 9 existing producing horizontal wells from another pad within the established 1,920 acre unit. Thank you for your time, the discussions, the questions, and your consideration today.
Great. Thank you. Thanks to all the attorneys for the closing statements. At this point, the commissioners are going to move to deliberation. And what I would like to do is have everybody that's not a commissioner unimpaneled. That way I can see my commissioners better.
We are working on it.
Okay. We're getting close. All right, commissioners. To start, I think my first question for us collectively as a group is everyone comfortable deliberating right now? I remind us that we have the ability to take this under advisement and look at our notes and, take slow measured steps in getting to the deliberative phase, or we can, launch right in. Does anybody have any thoughts about that? I think I'm probably okay just launching right in, but I did want to ask that question of everybody. Mike, John, Karen, in that order.
I'm fine, I think, going into deliberations now, especially depending on what everyone's thinking. I think it may be worthwhile to take some time before rendering a decision, but I feel comfortable starting deliberations.
All right, Commissioner Messner.
Thank you, Mr. Chair. I can start deliberations now. My notes are across 3 different platforms and in 2 different notebooks. And so I think 2 things. One, I mean, if you really want, complete thoughts from me, then some time would be better. But I'm happy to discuss some particular topic areas and work through some issues today. I also think some time prior to making a decision may be appropriate as well. Not a lot of time. I'm okay with overnight. I'm okay with the weekend, but that's just my thought. Now, if everyone is into like doing it this afternoon and being done, I can get there. So,
Okay, let's see what other folks are thinking. Commissioner McGowan.
Mr. Chair, I think I'm definitely okay starting a conversation today. I do feel like for me, I would like some more definitive with some of the BMPs that Broomfield asked for, and I think it's Ms. Stearman said that they didn't think they were appropriate, but weren't sure, didn't have enough time. I guess I would like some definitive responses about why these BMP requests might or might not be appropriate for the OGDP application and the types of equipment that are going to be used and or strategies. It felt kind of squishy to me, and I also understand that those requests maybe felt late. I don't think that we penalize people because they didn't provide feedback on the time schedule or the time frame that we wanted them to. There's still their feedback. They're still an important participant in this hearing, and so I was just thinking I would like some more definitive feedback on the BMPs that Broomfield asked for, and Crestone might need some more time for that.
Commissioner Ackerman, did you have anything to say?
Thanks, Mr. Chair. I'm okay with continuing deliberations. Certainly understand if we need to take a little more time as well.
When you say continuing, do you mean starting?
Yes, sir. Thank you.
Okay. All right. Well, let's thus deliberate amongst ourselves, getting started on this. Just trying to look at my 3 different piles of notes as well. I guess I can give you some kind of global perspective of where this head is at. I believe that Crestone carried its burden of proof. I believe that the science that they brought to the table carried that burden. I think that if you look at this and you didn't have the city and county of Broomfield, we would have already approved this because there's 2 informed consent. There's no other residential building units nearby. There are no other adverse receptors. It's in a good location compared to other locations. The ALAs, I think, showed that this is the best location. It's being electrified. It's got stringent emissions. It's got 3-phase takeaway. It is not using tanks. Weld County is in favor of it. The CDPHE is comfortable with it, with the BMPs that they recommended or that the operator agreed to from their list. The director signed off on it as approvable. The surface owner signed an SUA. So long and the short of it is, I think this is approvable. I appreciated Crestone's involvement and appreciated their bringing forward their health study, which others have labeled health survey. I'll just say health study. And I appreciated the level and effort of their air monitoring program. But weighing all of that scientific evidence, I did not feel that the city and county of Broomfield's scientific information outweighed the scientific information we received from Crestone. I appreciated the information from the 2 doctors. And I also tend to agree that we spent a long time getting to the spot that we're at with our emission change rules. And this could be looked at as, an effort to, not change, but like do something different. And so I think our rules are protective. I think they're protective as applied in this situation. And so that's where I am on that front. I also would like to speak to the Erie BMP request, just to get it all on the docket for everybody. I've got something prepared on that front. Give me just a sec. All right. During these proceedings, Crestone has both committed, both verbally and through a written stipulation, to comply with the BMPs in the amended and restated operator agreement between Crestone and the town of Erie. Specifically, Crestone submitted a letter to the town of Erie that is part of the record as Erie's Exhibit C, in which it states, quote, Crestone stipulates and further confirms that all BMPs applicable to the Coslet location under the operator agreement and those certain mutually agreed upon BMPs that supersede the operator agreement shall apply to the Coslet East location as set out in the application. The letter further acknowledges that COGCC may or may not include the BMPs on an approved Form 2A for the application. It states that Crestone will implement all applicable BMPs from the operator agreement at the Coslet East location, notwithstanding any decision by COGCC to not put the BMPs on a form approved 2A. The operator agreement, in my mind, provides that Erie, or it says that Erie may access the location to conduct inspections, and the BMPs are enforceable as a matter of contract by the town of Erie as against Crestone. Therefore, the operator agreement BMPs are enforceable by the town, regardless of whether they're incorporated into the COGCC's Form 2A. And in my mind, it is not necessary for COGCC to incorporate the Erie operator agreement in the OGDP. Now, having said that, I think that incorporating the Erie BMPs into our Form 2A could cause more harm than good. Weld County is the relevant local government, not Erie, and Weld County has the land use authority in this matter. And Weld expressed concerns about overlapping BMPs. I also note that many of the BMPs are already within our operator Form 2A from either CDPHE or COGCC or Weld County. And then finally, as I noted in my statement that I read, Erie has an absolute right to enforce the BMPs irrespective of anything we do. And then finally, I want to recognize the points made by Director Murphy and staff about a concern that, generally speaking, we ought not include operator agreement BMPs, in particular from a local government that is not the relevant local government, into a Form 2A. The final point that I would make on this whole thing is, and I respect and understand your point there, Commissioner McGowan, about, we could stay this, and I don't even know if we're going to get to a vote of 3 of us in favor of it, but I'm just laying it all out there. But if we got to that point, we could stay it and we could direct Crestone, as well as our staff, to further evaluate the 8 or 9 additional BMPs that were, launched into the record, at the end of the day. With all due respect, I'm not inclined to do that. I think that there is a process for local government involvement. We've created a lengthy process. We've created stakeholder involvement. We've created petition process. We've created relevant local government process. We've created proximate local government process. We've created anybody that's a stakeholder, we're going to listen to you. And frankly, I think, folks, it's helpful if we honor that process. And so, and I hate saying this, but I think that at this point, it is a safe location with the BMPs that we've already got on it. And I would consider just moving forward with it. And to the parties, this is not it. You've not put us in an easy place to make an easy decision. So I'll stop there. Commissioner Cross.
Thank you, Mr. Chair. I think I'm going to sort of go in an opposite order of what you did there. So starting with the BMPs, I'll be honest, as I was taking notes around number 4 or 5, I started to lose track of where we were. I agree. I feel like some of these proposed BMPs should have been brought up earlier, even at the beginning of the hearing. I think it would have been a little bit easier to do. That said, if everyone does want to look at them, I think it would be helpful if we got a a copy sent to us so we could look at them in a little bit more detail as opposed to my chicken scratch that I had here on my paper. But I would be in agreement. I feel like I do think there was opportunities to bring these forward, and I appreciate Broomfield's additional considerations for how to make this as protective as possible. But I'm a little concerned as to why it took until just before closing arguments to do so. With respect to Erie, I could not agree more. You know, coming at this as from a legal background, Erie absolutely has the power to enforce a contractual agreement. And I really don't want to get involved in trying to take on the enforcement of something that they have enforcement on. I think Director Murphy put it very well when she indicated that we don't want to try and interpret a contract without having been involved in the negotiations of the contract. That's up for Erie and Crestone / Civitas to try and determine. And so I don't think it's appropriate for us to put those in, because they being Erie have been given the opportunity to go in and inspect. They've been given the opportunity to access as necessary, notification within the agreement. And as you mentioned, I think it's important that the applicant has allowed for Erie to be involved in this. The applicant has agreed to the concerns that were given, and the steps to be taken to make this protective. As Mr. Sullivan expressed, I think that some of these are probably more stringent than what we require. And I feel a little uncomfortable going beyond what we require and beyond what staff has agreed to try and take those steps. And so I think because it is a contractual agreement and because Erie can enforce it within the courts if necessary, I feel like Erie's in the best position to be able to enforce that. Turning to the application itself, you know, I thought this was very interesting, and you know, I really appreciate having experts from both sides come in and talk to us about these different issues. And I think it highlights the importance of being able to use a professional commission to look at these different issues. Hearing some of this testimony when it comes to epidemiology and toxicology is definitely not my wheelhouse. And so being able to look at it from that perspective, get differing views of that, I think is helpful, and it shows the importance of not only the issues at hand before us, but also the differing views that we have within our state, and the importance of the public process that we're going through to make sure this happens. That said, when you look at the science of it, I will say we have a little bit of a post hoc ergo propter hoc issue when it comes to the veracity of the survey / study done by Broomfield. I think Commissioner McGowan in some of her comments yesterday put it very well. Are the people that responded, the 10.7% of people that responded, more likely to have responded because they're concerned about oil and gas? Or are they more likely to be concerned about oil and gas because they've had effects from the oil and gas operations in the past? And that's something that may be impossible to tell. A little bit of a chicken and egg problem. And, you know, in looking at it, I do think that there are bias issues by trying to say, we're looking at how we can shape oil and gas policy. And because of that, you know, what kind of effects have you had? And I think one of the things that was interesting is both sides sort of admitting we can't necessarily tie that oil and gas activity to these symptoms. Whether the self-reported is appropriate or not, I think both sides indicated that there is some level of self-reporting done. It's hard to tell. And so I think ultimately what it comes down for me is not the veracity of the study itself, but I think it goes into some of what Dr. McMullen, the toxicologist, said as well. Because while I do have issues with the veracity of the study, even if you take the way the study was conducted at face value, I think a lot of what Dr. McMullen said really hits on whether this is going to have a concrete adverse impact to public health, safety, welfare, and environmental resources. Specifically, when you look at the fact that they said a temporary shift in air quality doesn't necessarily correlate to adverse health impacts. And it's something that Dr. Wisner agreed that you can't concretely do it to that. And so I agree that there could be issues, but we're not noticing this for sure. And that last slide that came up in Dr. McMullen's rebuttal, I thought was helpful to kind of show how both the exposure time and the exposure limits can impact public health. And so looking at what Broomfield has done with, as was mentioned previously, a robust air quality monitoring system, the fact that there is still only a small number of incidents, especially those beyond 300 feet from the site, only a small number of incidents that had any kind of spike that was caught on the air monitoring, the bullet in the containers, as they called it. I think really, when you look at that in conjunction with the ATSDR information that says for acute, if you're exposed to this for prolonged periods over 1 to 14 days, or if you have chronic issues for a year plus, and we're not looking at that kind of exposure limits. We're looking at, there are small instances, even if you take Ajax's extrapolation and turning the 15-second bullet collections into an hour long and bringing that out, you're still only getting an hour of something that may go above that 9 parts per billion with respect to benzene, but you're not getting a prolonged that's going to match what those ATSDR standards are saying. And so I think to me, I think that's very important, is that I do think that we're seeing some compelling information from Broomfield, but I don't think that we're seeing enough to say the BMPs as proposed are enough to adequately protect and minimize and mitigate potential adverse effects to public health, welfare, safety, and environmental resources. And to me, that last part is what it really comes down to, and it's the BMPs. When you look at Broomfield's study, it was before we were looking at electric rigs. When you look at which Dr. Wisner indicated, you're still going to have some HAPs, even from an electric rig and electrified equipment on site. But the fact that even what you're looking at with what Broomfield proposed before is already going to be less with that electric rigs, I think says a lot. We're already taking additional steps, and the applicant has talked about additional steps that are going to be taken to make sure that we minimize, mitigate, and protect those public health aspects. And it was mentioned several times in closing, and I think it's important, and it's one of the things that jumped out to me this morning and I had from my notes. Commissioner Oath at the very beginning said, when you look at the BMPs that we have, we being CDPHE, when you look at those BMPs, CDPHE, who's tasked with this kind of protection of public health, has recognized that the BMPs the applicant has agreed to are sufficient, as written and is in the Form 2A, to adequately protect public health. And to me, that's what really sticks out, is you're saying there could be public health issues. Even when you look back at what was happening in 2018 as the previous wells were being done. The fact that Broomfield acknowledged, as Commissioner Messner's questioning went into detail on, the fact that many of these impacts are occurring during pre-production activities, and the pre-production on the previous multi-pad or the multi-well pads is already complete. I think that loses a little bit of the impact with that Venn diagram of the neighborhood that overlaps both within 2 miles of the previous extraction well pads along with the Crestone pad here, because you're not getting those continual impacts of the pre-production activity. You're only getting the new ones, which are going to have BMPs that lessen any impacts, even as shown by Broomfield here. So, you know, I do have some concerns about the survey itself, but ultimately what it really comes down to with me when I'm looking through all the materials that were presented, both during the hearing the last 2 days, as well as through what we've seen in the written materials, is that the BMPs that are in place, the BMPs that have been agreed to, both as presented by CDPHD and by staff here, are doing more to adequately protect those public health issues that are raised by Broomfield. And as you said, Mr. Chair, I do agree that if we didn't have this protest, if you just look at the site itself under the relevant local government, Weld County is in favor of it. They went through the process. They didn't have the protests in their process. They've done an adequate alternative location analysis to make sure that they're looking at all the possible spots where they could put this and where it is going to be the best possible spot that they could put this. They have this long laundry list of BMPs that they're agreeing to work on. And if it wasn't for this protest, we'd probably already be done with it by now. And that's not to say that we shouldn't have these protests, because I think it's important that, as we talked about, making sure that everyone, whether within 2,000 feet or not, has the opportunity to comment on our process. But ultimately, when it comes down to what I saw in the record and what I heard in the record over the last 2 days, is that the applicant is taking those necessary steps to protect what we're required under statute to protect.
Thank you, Commissioner Cross. Commissioner Ackerman.
Thank you, Mr. Chair. I appreciate that, and I agree with much of what has been said by you and Commissioner Cross. I did just want to start by saying I'm so grateful for the expertise that we've seen during this hearing. We've heard from literally doctors and lawyers, and they've done an excellent job of articulating their cause, and I really appreciate that. You know, they made it understandable for me, and they were clear on their points, and I just wanted to say that I really appreciate the arguments that have been made during this hearing. I also wanted to commend Erie for work and Crestone for working together to develop BMPs that they found mutually acceptable. I think that's very commendable. I think that getting involved early as they did, and that demonstrates Crestone's willingness to work together with even proximate entities, and I very much appreciate that. That said, I would agree very much that Erie's BMPs are contractually enforceable, and I wanted to make a clear statement that, you know, us not including the BMPs that are included in that contract in no way negates them. It simply puts them, it simply puts enforcement where, frankly, it should be, in my opinion. I think, for example, if you look at some of the BMPs, one of them is that Crestone must submit annual reports to the town, and that those reports must contain certain things, and that they must be certified to be true. And all those are good things. And I think Mr. Sullivan's point was a good one, that if we can get more public protection, why not do that? And I commend Erie for working hard with Crestone to do that. I do think that would put our staff in a difficult circumstance of monitoring, you know, reporting to the town and what that report contains. Or, for example, another BMP monitoring the town's traffic management plan and understanding what that is and monitoring compliance, just is not within the expertise of our staff. I don't believe it belongs there. And essentially, ultimately, what that does is it puts COGCC in a position where a potential violation of a contractual agreement that wasn't devised by the state, then puts a potential permit penalty in place or a potential permit suspension in place. And that might not be appropriate for a contractual agreement that was made between two entities. So I would agree that I think that those were great discussions. I think that they are exactly where they belong in that agreement, and commend Erie and Crestone for working together on that. I also, along that same vein, would echo your comments, Mr. Chair, that puts us in a bit of a difficult position, and that's okay. That's what we're here for. As Mr. Valdez and I talked about in this hearing, that's the art of interpretation and the art of negotiation, the art of setting rules based on a myriad of data. And as Mr. Valdez stated, that's what Broomfield did in determining the setbacks between legacy wells and new multi-well pads. That's also what we did in the Senate Bill 19-181 process, which was lengthy and intended to be protective of public health, safety, welfare, and the environment. There was a lot of detail that went into it, a lot of data that went into it, and also a lot of discussion and negotiation and art that went into it. And so while I commend Broomfield very much for assessing and addressing the wellness of its citizens, I would argue that this body also is intending to do the same thing, and that it's come to conclusions on setbacks and other things in its regulations pursuant to much deliberation. And as we heard today, it's not entirely empirically clear exactly what a setback should be from every location to protect every aspect of public health. That's part of the discussion that we're having here today. And so while Broomfield has chosen to allow development within 250 feet of legacy wells and within 2,000 feet of new multi-well modern pads, the commission has taken the also protective measure in its regulations of requiring 2,000-foot setbacks with varying stipulations. And who's right? Right? That's the big question. If we knew the answer to that, we could easily make a determination on this application. I believe the fact that Weld County is the local government, the relevant local government, provides them some pretty strong status. And we heard from Mr. Maxey that they're supportive of this application and that they went through a significant process. That said, Erie's very close to this, and so is Broomfield. I very much understand their involvement as proximate local governments, and their points made are important to me. And I appreciate Broomfield's intent to protect its citizens from further potential development that is potentially near this pad. I do think that, that development not already existing is part of my decision as well. But I think that the thing that really my decision hinges upon with regard to Broomfield's comments, absent the points that have already been made about, survey versus study, and very much couldn't be more appreciative of all the work that's being done, regardless of the debate on survey versus study. I love that we're working on it. I love that we're working hard to protect citizens. The part that's difficult for me is that Broomfield has placed us in essentially a go, no-go decision on this well pad. And I don't think the burden of proof has been met to make it a no-go situation with all the protective measures in place. And that's where I come from. I do wish very much that Broomfield would have been able to participate earlier on. I think they would be in a very similar situation as Erie, and I think they would have negotiated BMPs with Crestone, but that's me just crystal balling it based on what else has happened during this application. I wanted to touch on one thing we haven't talked about much at all during these deliberations, and that's wildlife. I'm often very vocal during these meetings, and that's because there are often significant wildlife concerns. And, I've been pretty quiet during this hearing, and that's, in part, at least, because this is one of the few locations where there just, frankly, aren't any real wildlife concerns. And we talk a lot about development in wildlife high priority habitat. We don't talk as much about development in other wildlife habitat, but we do talk about it. What we don't talk about very much is that almost every wildlife biologist in the state would say this is one of the better locations they've ever seen. It's next to already disturbed development. It's next to I-25, which already has significant emissions and noise pollution. And so from a wildlife protection standpoint, I just wanted to point out that, you know, often when we put these or approve these locations in wildlife habitat, we make concessions. And, you know, part of our job is to protect wildlife. And those concessions are made with BMPs in place to do our very best to protect wildlife. In this case, no concessions need to be made for wildlife, but they do need to be made on the human front. And often those things are diametrically opposed. And we as humans in our developments would like to see these, you know, for our own welfare and viewscape and enjoyment and quality of life, would like to see these developments somewhere else, out away from us. And out away from us is where the wildlife live. And so it's one of those difficult situations where you have give and take and a difficult decision to make. Mr. Chair, I'm in the camp of, I believe a good case has been made here by Crestone. I believe a good faith effort has been made to negotiate and to set forth BMPs that are over and above and beyond those that we've set forth in Senate Bill 181, which was a very good faith effort to protect the citizens and public health safety and environment and welfare and wildlife resources of the state. And therefore am likely in favor, Mr. Chair, of this application moving forward.
Commissioner Messner.
Thank you, Mr. Chair, and thank you to the commissioners that have gone before. Always good to hear different people's thoughts. I'm probably coming from this in a little different light, although I certainly appreciate the thoughts that have come before me. And I'm not sure I don't get to the same place as folks, but I think I have a little different thoughts or different perspective. I mean, I do want to start with what I think a lot of people have said is that I really appreciate the testimony, the information that was provided by all the parties in this hearing. I mean, I think this is the first time that parties have utilized their new authority to petition for involvement in an OGDP hearing. I think that was a really important part of Senate Bill 19-181. I think it was a really important part of the mission change rulemaking. And I personally think it's really important that it is utilized. You know, having said that, how it's utilized is another part of the equation. I think during the mission change rulemaking, there was significant discussion as to whether or not proximate local governments should have any say in the permitting process. I think some of the advocates stated initially that they felt it was certainly possible that applications would consider oil and gas locations so close to their boundaries as to potentially implicate public health concerns for residents within those boundaries. And so therefore should have say in the permitting process. I think some other thoughts on the other side indicated that it is clear Colorado law that the relevant local government has land use authority within its jurisdictions in addition to the state, and that those two entities should be the only entities to determine the outcomes of applications. I think there are clear instances in local government where adjoining entities work together in land use applications that have dual implications. I've experienced those in my time in land use and in local government. My experience with those is though that they're most often governed by some type of 3-mile planning agreements or other sorts of MOUs between those two entities that clearly lay out how the interactions are to be governed. I think in the mission change rulemaking, we really did try to work through the different ways that proximate local governments and relevant local governments in the state were going to work through some of these issues in the way that we developed our rules. And that in the mission change rulemaking, it was made clear that in all OGDP applications that there was strong encouragement for all parties whether they are relevant local governments or proximate local governments or other agencies in consultation, work together in pre-application meetings to work out some of the details and concerns regarding siting, BMP and BMPs and operations. I think that pre-application and early consultation and often consultation to really develop those lines of communication and collaboration in some of these sightings decisions were an integral part of the conversations we had during the mission change rulemaking and are an integral part of the rules that ultimately were created by the mission change rulemaking. I think in this application, there was opportunities at the local government level. I think there were opportunities at the state OGDP review level for those interactions to occur. And while I acknowledge that Erie did engage earlier, they certainly didn't engage into all of the very early opportunities that they had as a proximate local government to consult in the relevant local government's proceedings, as well as the early pre-application opportunities within the state. And that Broomfield didn't engage in either in a pre-application type meeting with all the relevant entities. And so I guess I'm frustrated that for some time through this process that the parties just sat in their corners and threw grenades at one another. And that's not what the mission change rulemaking really was designed to facilitate. It was designed to facilitate those conversations, understanding that it was possible that locations were going to be considered that were close to jurisdictional boundaries. And so while I'm appreciative that we're here and we're having these conversations, I don't think this is a great blueprint on the way that this should work. I do think that the relevant local government jurisdiction is an incredibly important concept, and that particularly in their land use authority. And I don't want to see any process that we do interfere with, besides the authority that the state has, interfere with the local government's land use authority. At the same time, I think that the mission change rulemaking really did set up or facilitate the opportunity for a consultation or communication amongst all those different entities to try to alleviate some of those concerns and encourage that communication. And unfortunately, in this instance, I don't feel like that happened particularly well, which was frustrating. I also don't think that that opportunity has come and gone either. So I will indicate that before I continue. I think from the application standpoint, I do think that the alternative location analysis was appropriate. I do think that the location meets the extensive rules that were put into place through the rulemaking process for siting. It misses, a lot of the major receptors that we typically see, well, not typically, but often see in applications, in OGDP applications. We're not around schools, we're not around wildlife, there's not water that's associated with it. There's, while there was 2 homes that were within 2,000 feet, they both signed informed consent, which was a clear opportunity within the rules. I do think that a lot of the BMPs that were put in place were over and above even what would have necessarily been required within an OGDP application in this particular location. I do think that the BMPs that are being proposed are appropriate and important. And so I really appreciate that. I do think that that there's always opportunities within these OGDP applications to really look at cumulative impacts. And look at offsets by P and A wells in order to be able to offset any additional new impacts that may occur in any part of the state. I think there was an opportunity here to have a clear no net adverse cumulative impacts associated with offsetting wells, if that was something that was pursued, and I think it was considered at one point. And I think that still is a really strong message for operators to engage in, is to be able to say, I'm putting in 19 wells, I'm offsetting 19 or more wells. I think that that's an easy offset for people to understand, even though it's not always apples to apples. I think that that does, to me, show a desire to not have additional net adverse cumulative impacts, which is an important consideration for me. I mean, listen, 2,000-foot setback was the science that we determined for being protected during the mission change rulemaking. I read dozens and dozens of public health studies and other studies and analysis and hours of testimony on, you know, public health implications of oil and gas activities. Most of those studies were peer-reviewed and published studies. And so that still stands. That's to me where our north point is in these particular applications, is the work that we did and the analysis that we did through the mission change rulemaking. And you know, while we had dueling scientists here today and yesterday talking about their non-peer reviewed and non-published studies around public health impacts. And I certainly think that their opinions are valid, and I don't mean to demean them by any means, but I mean, I think we've gone through this debate and gone through this analysis. And I think that there will be better and more studies that are to be done. And I think we need to consider those, but I think they need to go through the process of getting published and peer reviewed and then considered in our process. And so that's another thought I have on that. You know, I think that, you know, I do think that this was, in the way that it was approached, it was really an approach to utilize the survey as a tool to kind of overrule that work we did in the mission change rulemaking and de facto create a 1 to 2 mile setback from oil and gas activities in the state of Colorado, or certainly around the city and county of Broomfield. And I think that's inappropriate application of the opportunities that are created in our rules for the proximate local government to engage and influence perhaps an OGP application as it relates to impacts within their communities. I think that the BMPs that Broomfield proposed at the very end, you know, would have been great BMPs to propose and consider early on in the application process for adoption by Crestone. I think those types of actionable specific items are what that proximate local government engagement is really designed to facilitate. And I think that's an appropriate way to utilize those. As to Erie's specific BMPs that they're proposing, and this is in a quick glance as I went through them, but you know, I think the vast majority of the BMPs that they have associated in their operator agreement are covered. I think some of the other BMPs that they have in there are probably most likely covered during the CDPHE air monitoring review. And I think some of the specific things in here around that are redlined within their BMP kind of cross-reference, you know, are really unnecessarily enforceable things by a state entity, but ones that can easily be enforced through a contractual agreement. I don't see anything in here that's problematic or would require even consideration of adopting the entire operator's agreement. And so I don't think that there's any concerns in there. I think that the BMPs in there are appropriate. I think the vast majority of them are already incorporated. And I also think that operator agreement is really designed at its root for operations that occur within the jurisdictions of Erie, and really where it should live. I mean, where it was designed to live for the most part. I understand and acknowledge that this one is in there, and I appreciate the director's or the chairman's statement on that as a finding of fact. I told you I have 3 different platforms, and I'll be rambling because I didn't have time to get everything together. So I think I can stop there right now. My other point is I mean, I hate to see the conclusion of this be that the 3 entities here still sit in their corners and you know aren't going to work together. Because they're going to be neighbors for the next 30 years, you know, plus for the different operations. And I really think that it would be unfortunate if the outcome of this was not the different entities to be able to sit down, work together, and, you know, work out an agreement that would be mutually beneficial for all involved. And I would like to be able to consider offering that time, although I have heard from the different parties that this is it, take it or leave it. And then I've heard from other parties saying, well, we're going to leave it. And so anyway, that's my kind of end on that. I think that this application is approvable without the additional BMPs. I think it would be unfortunate for that consideration to not be made amongst neighbors, which is really the spirit of what we tried to develop and facilitate with proximate, relevant local governments and operators in the mission change rulemaking. So I'll leave it at that.
Commissioner McGowan.
I'll try to be brief. I think folks have said most of what needs to be said. I will say, I think Commissioner Ackerman's point of Broomfield starting from a go, no go kind of made it difficult as a commissioner to figure out, and I think maybe difficult for Broomfield to negotiate with Crestone some of the BMPs earlier in the process, because they were starting from a place of, we have information, we have data, we have a survey that shows that maybe the 2,000 feet isn't protective. And I will tell you, I don't think that they demonstrated that today. I do think the health survey is important from a perspective of what's happening in that community that has to be honored and respected when it's shared with us. Whether it's scientifically valid or not, and certainly can't show causation. This is a community that feels that oil and gas has affected their quality of life, and we need to take that into consideration. And when someone next door, next to them, is going to plop something down, the whole reason we came up with relevant government and proximate local government was to provide a platform for those neighbors to share their concerns and, quite honestly, to oppose an application. I feel like, you know, it's unfortunate we don't control the politics of things, and that Broomfield may have started from a place of no go because we have this information and we think it's going to prove to you that this should be denied, which they didn't. And there doesn't seem to be a plan B that they were working on ahead of time with Crestone. You can still oppose someone's application, but work with the operator to say, maybe it won't get denied. And if it doesn't get denied, these are things we'd like to see. We're still not really happy with this application. And I'm not sure that that occurred. And I also feel like Crestone here pretty much said, if you give us, we'll give you some things, but then you can't oppose our application. So there's gamesmanship and there's politics, and we as commissioners can't control that. So to a certain extent, we're kind of left with, I think to Mesner's point, everyone kind of in their corners and not realizing that they are going to have to be working with each other for many years around this location. I also think that P&Aing, offering to P&A more wells doesn't just benefit Broomfield because they asked for it back in the day and then things fell apart. It benefits Erie, Broomfield, Weld County, all of those communities that are near this pad, near these existing older facilities that potentially are emitting emitting more things than this new facility would. So I will say there's a lot of things to appreciate about what Crestone put on the table here, which I think our fellow commissioners have already put up. Electric rigs, tankless, piping out all the fluids, a new monitoring system to hopefully catch leaks if there were any much quicker, a willingness to share data. I think that there are some good things here that Crestone's put on the table that we as commissioners have kind of been pounding on when we've been seeing other OGDP applications, within communities. I think they did a good alternative location analysis. I think it's probably the best location for this spacing unit. I think I'm just disappointed in how this process played out. I also don't think that just because someone didn't participate in the order in which you wanted them to participate is a reason for kind of dismissing what it is that they're asking for. Broomfield submitted what they thought was their early start in the process, dates that they started talking with our staff, maybe not necessarily Crestone. So I don't feel that they just started participating at the very last minute here. So maybe I have a different opinion about that. But this is an approvable application. But I do think it's important for us to listen to what the proximate local governments are asking for, even if it's maybe a little late. And I think it would behoove the operators to listen and also have a plan B available when maybe there's some low-hanging fruit things for us to say yes to and offer up.
Thank you, Commissioner. Thank you to all the commissioners for that information. So where do folks want to go from here? I think we've all made the statement that we believe the application is approvable. I think there's agreement that the Erie BMPs not be attached. Commissioner McGowan, I don't know if I heard you speak to that point, but I know the 4 other of us are in agreement on that front.
Yeah, I agree. Based on staff's concerns about including the operator agreement as part of our BMPs, I agree.
Okay. Then I think that the remaining debatable topic is what to do with the BMPs or requested COAs that were submitted, toward the end, right before closing. I had opined that I was a little disappointed, and I think Commissioner McGowan and Commissioner Ackerman, you both sort of expressed, there could have been a plan B developed by the city and county of Broomfield early on in this process. You can always plead in the alternative. We don't want it, but if it happens, then here are things we think are important. I agree with Commissioner Messner that I don't like that we're sort of ending up in a spot with 3 partners, for what a better word, still not talking. If we move forward and don't put the BMPs, I could be in a very, very comfortable place there. I think that what I want to see is I want process improvement. And as we move forward, in particular for proximate local governments, I think you need to, state your case, and we're happy to hear it. And I really want this proximate local government thing to work. But I think, the thought of a plan B does make some sense. And I have all the respect in the world for Elizabeth Paranos, and she knows that. What are other thoughts? Do you want, so the other option is to table this for a period of time, and instruct the parties to think through it. I believe that the director also needs to spend, if we're going that route, our staff's going to have to spend more time on this, because in my understanding of trying to scribble down what the BMPs were, some of these are unique. They're not like the things that we've been asked to consider before. And so we're going to need to run that down, some of our engineers' minds if we're going that path. So we would need some time. Commissioner Messner?
Thank you, Mr. Chair. So it's my opinion, it appears that the BMPs were all developed, that probably were developed a little quicker than hoped and haven't been analyzed as much or applied specifically to the proposed operations on this site, or even that communication of Broomfield communicating to the operator, hey, this is what we're really concerned about. We had these issues in the past. This is that caused some consternation. What are you proposing in this that would either not cause those things, or are there things that we can consider in order to minimize those? It's like that basic level of conversation as far as developing, or at least acknowledging existing BMPs that will address that, or acknowledging that there may be one or two tweaks that may alleviate some of the concerns that Broomfield may have with the particular technology that's being proposed on the site. I think I would propose, listen, I mean, these parties can all sit in their corners and not communicate with one another, and that's their prerogative. I'd still like to create that opportunity for that to occur, and because I'm an optimist. And so I mean, I would propose either staying this until tomorrow afternoon or Monday to allow that to occur. And then
Mr. Messner, if we're going to stay it, we probably need to stay it for at least a week, because
that are posting requirements.
Just because some of this is new and different and our staff has not analyzed it.
Well, can't we continue it?
Yeah.
That's
I mean, we can just continue it to next Wednesday.
All right. Well, you guys will you'll make a determination without me, but I will trust you on that.
Oh, that's right. When is your last day? And then you're taking some time off.
Right. So anyway, like I said, I mean, the parties can stay in their corners and whatever. I was just making some time to, I don't think this is, I do think that there's an opportunity to come up with a few BMPs that are going to work and that aren't, that wouldn't take, staff to be able to do significant, analysis on them, but just a consideration, because I think some of these things have already been considered on the side, but that's just my thoughts. So
yeah, and I've been informed that it is going to take a little time on our staff's part to do the correct analyzation as to the science behind some of the BMPs. And so while I would, always desire to have your presence, I think we know, your perspective. And again, I don't know if we fully understand. Well, just a sec. What are others' thoughts? Commissioner Cross, Commissioner Ackerman?
Thank you, Mr. Chair. I'm swayed by the fact that this is our first petition for proximate local government involvement. I think there's a learning curve there, and appreciate Commissioner Messner's comments. I want to be as inclusive as possible here. I reiterate that Commissioner Messner's point and Commissioner McGowan's point was a good one, that, you know, we need to continue to get parties to try to work together as much as possible. And in the end, you know, I don't want to hold Broomfield's feet to the fire, even though they gave us a no-go decision, no-go decision. I don't want to, if we have an opportunity for it not to be all or nothing for them and their residents, I recognize that and believe that the citizens of Broomfield should commend their public servants for working hard on their behalf. And we're learning here. And so I would support a stay. I do recognize that that's a burden on COGCC staff. That's what we're here for, and it's not ideal, but I recognize that's a burden and I don't take it lightly, but sorry, Mr. Chair, go ahead.
I got some follow-up after you're done.
Oh, okay, thank you. I was just wrapping up my comment there, but I would be in favor of, if we believe that there's some opportunity for the operator and for Broomfield to come to some common ground, this being the first opportunity of relevant local government involvement in this process. I wouldn't expect this to be the blueprint as per Commissioner Messner's comments in the future, but I certainly am willing to make some allowances for it the first time.
So my thought was going to be that it likely could be kind of an iterative process. Broomfield has asked for these 8 BMPs. Crestone could do its evaluation as to whether they are applicable or feasible or practicable or whatever you want to call it. We're giving direction that we want to see them as agreed upon BMPs if they're doable. And so we could direct Crestone to do the initial review. And then for the subset of ones Crestone's going to be okay with, staff could then only review those as opposed to having staff reviewing all of them. And that could be direction from this commission to allow Crestone the initial opportunity to make a determination. And Crestone, we would be telling you, we want you to do this as a reasonable neighbor, and we want you to adopt those that are available for you. What are folks' thoughts about that as direction? Commissioner Cross, Commissioner McGowan.
Thank you, Mr. Chair. And I'd like to start up saying, and again, I was having a hard time getting all my notes down on some of them. And I think Ms. Jost did provide some initial analysis. For example, I think the red flag days and the hot work, I think, was something that they already do. The ultrasound emissions, the ultrasound was something that was not feasible, I think I heard them say, and Ms. Jost also provided some analysis with respect to the plugging and abandoning. I'll say I am also hopeful that they can work together, and if the other commissioners are wanting to try and get these parties again to talk together and see if they can come to an agreement, I would be fine with that. I'll admit that I'm not as optimistic as Commissioner Messner, just based off of Crestone's council's initial comments and response. But I would be okay with having that extra time for the parties to try and talk and try and get something so we can appease everyone to the extent possible.
Commissioner McGowan.
Thank you, Mr. Chair. I do like the idea of allowing a little more conversation between Broomfield and Crestone, even if it could give Crestone some more time to say to Broomfield, it doesn't make sense because the setup that we have here, it's not feasible for the following purposes. You're not going to get much benefit if we do this, or we can't do this, but here's an opportunity for us to do something together or something different. And or to Commissioner Cross's point, we already have BMPs in place that cover what you asked for. It just feels like some of the responses were really quick. We're not sure. Don't think it makes sense here. We don't even know what this request is. So it just feels to me like there hasn't been a conversation. It doesn't mean that I think that all of them are going to be feasible or necessary, but it would be nice to see some sort of dialogue back and forth between the two to explain why or why not.
All right, it seems we are appearing to be in consensus that we would continue this matter to allow this discussion to take place. I think if that's the consensus we're at, I would like to impanel Ms. Jost and Ms. Paranos to get a sense of timing. Hearings Manager Larson, can you do that? Hearings Manager Thomas, can you do that? Oh, I see them. Okay, I trust you all have been listening intently to the commissioner deliberations. I think we've reached a space in which there's consensus that we would continue this for a short time to allow the parties to have discussion about the last minute BMPs that were produced. Ms. Jost, can you provide some perspective in terms of time that might be allocated that would be reasonable for you and your client?
Yeah, and Chair, I appreciate the opportunity here. And before I get to any potential time on this, I really do feel that, you know, Crestone was clear in the fact that it would not be putting any of these BMPs on this location, whether looking at these in 12 hours or not. Ms. Stearman was very clear with respect to her concerns with these. These are just not necessary for purposes of these locations, especially when you have Broomfield coming in at not only the 11th hour, but the 11th hour, trying to put BMPs on that otherwise could have been addressed 2 years ago. And so, you know, I hate to take this time to do this, but this is the only opportunity to remind the commission as to what we testified to, and that we will not, they don't want to put these BMPs on there. We're always open to talking to Broomfield, and we've been open to talking to Broomfield about this for 2 years. We don't feel that this is really the appropriate time to put these BMPs on long into
Ms. Jones, time out. Don't talk to me about the time. I agree with you, and I've already admonished Ms. Paranos that this late thing is not appropriate. And she's a colleague of mine, and it was terrible to have to do that. How much? Forget it. Commissioners, I say we just continue this to next Wednesday, and I direct the parties to work in a reasonable manner to either get to some agreement on these BMPs, and if not, Ms. Jost, I would like your client to be able to come back and not just yell at me right now, but instead in a calm, reasonable fashion, explain to me and the other commissioners why it is that all 8 of these are unreasonable and unnecessary. Okay?
Yes, Chair, thank you. And I didn't mean to come off aggressive or anything. We just wanted to ensure that the understanding was confirmed with what Crestone had testified to. So thank you for the opportunity.
Well, I think now you've got some time to, in a slow measured step, review the BMPs that are not hastily before you. We'll take it back up on next Wednesday. And now you both have frustrated me. So great. All right, commissioners, I would suggest we move to continue this matter to whatever is next Wednesday, that hearing date, Wednesday, October 26th.
So moved, Mr. Chair.
Second.
We have a motion and a second to continue. Is there further discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Okay, motion carries. This matter will be continued to Wednesday, October 26th at 9 a.m. or thereabouts. Thank you, everybody, for that. With that, I believe that we have concluded the work today. I would note that we were supposed to have taken up the Erwin Martinez Fund earlier today, but our day got filled up with this matter. And so that has been continued, commissioners, to the earliest date we all had availability. I think it's after Commissioner Messner is back. And so with that, we would look for a motion to adjourn.
So
Second.
Motion by Commissioner Messner, second by Commissioner Ackerman. All those in favor signify by saying aye. Aye. Any opposed? We are adjourned.